Hello friends, in the series on income tax cases today we will discuss a very important case regarding the jurisdiction of the assessing officer to pass the assessment order. The issue before Delhi ITA I bench was that if some assessing officer passes an assessment order by assuming the jurisdiction of the assessee from Bombay to Delhi without order under section 127 and the assessee do not challenge that jurisdiction within 1 month from the issue of the notice under section 143 subsection 2. So whether in that case the assessment can be quashed in the absence of section 127 order. This issue has been decided by Honorable Delhi ITA I bench in the case of Zavient Information Systems India Private Limited versus Deputy Commissioner of Income Tax, and this case is and this reference number of this case is ITA number 472/Delhi/2017, and the date of the judgment is 3rd June 2026. The facts of the case are like this. In the present case, the assessment of the assessee for the assessment year 10-11 was completed under section 143 subsection 3 by Mumbai Circle 18/4. The assessment of the assessee for the prior year, that is assessment year 9-10, was completed by Mumbai 8/3 Circle, and the assessment of the subsequent year, that is assessment year 11-12, was also completed by Mumbai Circle 8/3. The assessment was completed, additions were being made, and when the matter was before the tribunal, the assessee raised the legal issue that in the present case, since the jurisdiction of the assessee was with Mumbai officer and the assessment has been completed by Delhi officer without order under section 127, so the assessment is bad in law. The revenue raised a point that in the present case the assessee has not challenged the jurisdiction of the assessing officer within 1 month from the issue of the notice under section 143(2). So in that case the assessee loses the right to challenge the jurisdiction now. Now the issue before the tribunal was that whether the territorial jurisdiction as per section 124 subsection 3 applies. The tribunal said that section 124 subsection 3 applies only where the assessee challenges the territorial jurisdiction after 1 month. In the present case, the section 124 subsection 3 will not apply because in the present case the assessee is not basically challenging the territorial jurisdiction, meaning thereby that the assessee is not challenging that the assessing officer B has made the assessment but the assessing officer A should have made the assessment, but the assessee was challenging the very inherent jurisdiction of the assessing officer, that the assessing officer was not having the jurisdiction to issue the notice for assessment. There is difference between the territorial jurisdiction and basically no jurisdiction. In the present case, since the case of the assessee was transferred from Bombay to Delhi without 127 order, and even the facts of the case reveal that in the present case for the assessment 8-10-11, even the 143 subsection 1 intimation was issued by Bombay, but the assessment was made under section 143 subsection 1, but the assessment under section 143 subsection 3 was made by Delhi officer without 127 order. So the tribunal said that in the present case the Delhi officer was not having the jurisdiction at all, and section 124 subsection 3 will not help the revenue. The tribunal also clarified that section 124 subsection 3 applies only when there is issue of territorial jurisdiction, but in other cases where the assessing officer do not have the jurisdiction at all, like in the present case, and in other cases also where the assessee challenged the pecuniary jurisdiction of the assessing officer, in those cases the section 124 subsection 3 will not come for the rescue of the assessing officer. So in the present case the assessment was quashed in the absence of section 127 order for the transfer of the case of the assessee from Mumbai to Delhi. At the end of this video, once again I am repeating the name of the case. The name of the case is Zavient Information System India Private Limited versus Deputy Commissioner of Income Tax, and the reference number of the matter is ITA number 472 Delhi /2017, and the date of the judgment is 3rd June 2026. Thank you, friends.